They asked me to serve on this panel because I was coming in anyway for the early one, and so they've got to save money. Let me say two things in response to, I agree with both of the speakers ahead of me. I don't think there's enough in these reports. And I got to show you some cases from wrongful convictions using hair evidence where I think some of these problems could be eliminated or at least diminished if we had better reports. But what occurred to me is that I just read yesterday on the plane coming in the North Carolina Bar Association report on the Duke lacrosse case, the prosecutor Michael Nifong. And what he did with the DNA evidence is he orally told the private laboratory, just give us the positive results that help this case. Don't give us the facts. Don't write down the fact that there were other unidentified male DNA profiles in the vaginal swab in the rape kit. And then he went to court, went to discovery motions and so forth. All right, that Bar Association, in disbarring him, found that that is unethical conduct. It also violates the discovery rule. And what you're going to see is probably going to be a civil rights suit against him. And the civil rights suit, the 1983 actions, will be against the lab examiner as well. So there are these Brady issues, lab examiners, Brady extends to the examiners. It's not clear how much, but lab people have been sued in these wrongful conviction cases for their lab reports if they did anything that was not proper. There's a case that in the last year was reported out of New York, a Brown case. He spent 15 years in prison. It was a bite mark case. The prosecutor got a bite mark expert to come in. The bite mark expert told him that he would exclude the defendant as the suspect. The prosecutor said, don't write that up. He went and got a local dentist who included the suspect. All right, 15 years in prison. Then he's exonerated by DNA. So it's unethical, in my view, for a lawyer, a defense lawyer, or, well, defense is a different situation, but certainly a prosecutor to tell you not to write something up. And police officers aren't bound by the ethics of the legal profession, but that's a red flag. Somebody starts telling you, don't write something up in your report. Okay, that's a red flag that you're in dangerous water. Let me look at some of these cases. I go back to the Williamson case, very critical of hair analysis, saying it didn't meet Daubert standard. But look at it says microscopically consistent. But then he adds there could be another individual somewhere in the world that would have the same characteristics. All right, that seems to me, as a layperson, almost the same as what you could say in a DNA case. Does he have a scientific scientific support for that statement? The prosecutor, and this is what's going to happen, they're going to even go further, use the word match without explaining it. And the state appellate court, continuing this, says the hair evidence placed petitioner at the decedent's apartment. Edward Honecker, exonerated from DNA. Expert said the crime scene sample was unlikely to match anyone other than the defendant. But another expert later said the hairs were not comparable. Okay. Central Park jogger case. Prosecutor pointed out the hairs from the jogger were found on two of the suspects. How could that have happened if they were not involved? DNA exonerates them. State versus Bromgard. 15 years in prison, exonerated through, I think it was mitochondrial DNA. This is the case. What he was convicted on, the expert said the odds were 1 in 100 that two people would have head hair or pubic hair so similar that they could be distinguished by microscopic comparison. Then he comes up with a 1 in 10,000. It's still not clear to me how he did that. The Innocence Project, as it does, I know there's some people in this room have worked on some of these peer review reports, say that there never has been a well-established probability theory in the hair area, and they said you should look at his 700 other cases. The Attorney General of Montana refused to do that. Nelson versus Zant, the state's expert testified that only, 120 people in the entire Savannah area could have this type of hair. FBI later says it's not suitable for comparison. Oklahoma City, Joyce Gilchrist, her reports, all of them, over 20 years, were best incomplete and worst inaccurate and misleading. In the McCarthy case, he just was released 2 weeks ago. Her testimony that he was present at the time of the crime from the hair analysis. And the FBI reviewed her cases, misidentified 6 cases, fibers in 1, no laboratory notes, incomplete documentation. All right, this runs through Fred Zane, all these cases, no documentation, bad reports. Guy Paul Marin is a Canadian case. In Canada, when they have a wrongful conviction, they look at it, and they had a commission. This judge did it, and he was convicted on snitch testimony and hair evidence. This judge came very close to saying it shouldn't be allowed in at all. Now, Doug Lucas, and I'm sure you know that he's very a noted forensic scientist, look in the Journal of Forensic Science, said, look at these reports. He's criticizing them, leaving stuff out of reports, saving it for cross-examination, trying to sucker somebody in and give it at the last moment. The other thing, I was on this bullet lead comparison. The report said that the bullets were chemically indistinguishable. And the question is, what does that mean? The testimony is they could have come from the same box. But the committee said, well, we can't say that the range of melt could be anywhere from 12,000 to 35 million, depending on the type of, the size of the melt and the type of the caliber of the bullet. Same box, 20, 50 cartridges, that's a very different statement. All right, then what happens? The state, in the bullet lead cases, the state asserted in this New Jersey case that the bullet evidence showed that came from the same source of lead at the manufacturer, but was sold in the same box. Okay, so you see from the expert to what the lawyers do with it. The bullet lead committee said that the lab reports should be expanded. They should specifically state the limitations of the evidence. And I'm responsible for this one, so you can get mad at me. A section of the lab report translating the technical conclusions into language that a jury could understand would greatly facilitate the proper use of this evidence in criminal justice system. And that's also in the ABA's DNA standards in the report as well. Let me stop here. These reports, a report like anything else, written communication, you're trying to communicate who you're trying to communicate to the criminal justice system. All right, if you write it, the average juror's got about a 9th grade education. Doesn't mean they're not intelligent, just that's the educational level. And so your language, and people know how to do this, not lawyers, okay? If you ever read jury instructions, lawyers don't know how to write clearly. But there are people who do linguistics that know how to write clearly. And if that section is written for, the significance of the report is written for a jury at an 8th or 9th grade educational level, then the police will understand it, the prosecutor will understand it, the judge will understand it, the defense attorneys, okay? And there's no reason that that cannot be done. You might have to hire somebody who knows how to write in plain English, but that can be done. You'd only have to do it for 1 or 2 times until you had your template. The Guy Paul Marin case out of Canada, same thing. The report should include the limitations to be placed upon the conclusions. Why do you have some of these cases? In the Trodell case, this is a capital murder case out of Florida. And this is the report. Gunshot residue test reported, which is the typical one as I understand it. The antimony barium indicated that a person discharged a fire. It's indicative the person discharged a weapon or was in close proximity. That's the report. There's 2 separate trials. And the expert who did the same report on both of these guys gave different testimony in the two trials. In Trodel's trial, he said that Trodel had fired the murder weapon. But on a post-conviction habeas proceedings at a deposition, the same experts could not, from the results of his test, determine or say to a scientific certain who had fired the murder weapon. He's contradicting himself here. And he said it was basically insignificant, the testimony. And the court just overturned this violation of due process. The information was false, and it was knowing and was used by the prosecution, knowing it was false. So it's not only unethical for an attorney to do this, it's also a violation of due process. Now, what's going behind here? So the expert candidly admitted in his deposition that he was pushed further in one case than he was at the other, and the prosecutor admitted that as well in the post-trial proceedings. And in an adversary system, you have to expect that. Here's Joyce Gilchrist's case. The Oklahoma County District Attorney's Office placed undue pressure on her. So you see this over and over again. It's not that the defense attorneys are any different, okay? They push their experts the same way. It's part of the adversary system. It's the lawyer's fault. Well, all right, but this is what I want you to know. The ABA Criminal Justice Standard says a prosecutor, the same one applies to the defense attorney. Cited, a prosecutor who engages an expert for an opinion should respect the independence of the expert and should not seek to dictate the formation of the subject matter. And the commentary says what you all know. Statements by physicians, psychiatrists, and other experts say the lawyers push them. All right, how do we deal with this? We're not going to change the adversary system. It's part of our historical heritage. It's in the Sixth Amendment to the Constitution. But if you know what weakness is, then you can try to deal with those weaknesses. So I believe that these lab reports should be complete, although I'll leave it up to you to tell me what complete means, because I don't know. You must state the limitations of the technique, and I would want a, quote, jury section in plain English to explain what this means. Okay, you have overworked prosecutors, overworked defense counsel, overworked judges, all right? They cannot go through the report. The defense attorney in the Duke Lacrosse case finally got the DNA data, but not the conclusions. It took him 40 to 60 hours to figure out that there was exculpatory evidence. Most attorneys won't do that. I'm sorry to say that. But a lot of attorneys don't have that time, or they don't have the knowledge of the science and so forth. So you have to spoon feed the science into the criminal justice system, or it's going to be misused. And I think that's your responsibility as the scientist, as well as mine as an attorney. Thank you. And I believe that the expert testimony should not go beyond the report unless there's a supplemental report issued. So you see over and over in these cases, the report says one thing, but the person goes further in the testimony. Now, there's sometimes a supplemental report. You get different information or more information. It's certainly proper to change your opinion and so forth, but it should be in writing, and it's supposed to be disclosed under the discovery statutes. And I've independently come to the same conclusion that Tom said. This will protect the expert from the lawyers. That if you decide what should be in the report, and you have the scientific basis for your conclusions, which you obviously should have, you have no business going into the courtroom, then you state it in the report, and when the police or the prosecutor or you work for a defense attorney say, okay, I want you to go beyond that, you say, I cannot, this is the lab policy, I cannot go beyond the report because I don't have a scientific basis to go beyond the report. All right, so you do not want cowboy or freelancing in the courtroom by the experts. All right, so that you know when this expert, the lab sends out this expert ahead of time, that that expert's going to stay within the four corners of the report, or if there's something comes up at the trial and you have to call back to the lab and get a supervisor to change that, I mean, those circumstances, okay, then you deal with that, that possibility. That's it.